Kia ora koutou. We'll just wait another minute as we've still got people coming in to the webinar. Okay, just get started with a karakia. Whakataka te hau ki te uru. Whakataka te hau ki te tonga. Kia mā kina kina ki uta. Kia mā taratara ki tai. E hi ake ana te atākura he tio. He huka, he hauhunga. Haumie, hui e, tā ki e. Well, kia ora everyone. My name's Jette de Jong from Network Waitangi Whangārei, and you're very, very much welcome to this online webinar. We're very privileged to have Melanie Nelson, a regulatory standards bill expert with us tonight. So just quickly, a bit about Network Waitangi. We're an independent voluntary community group based in Whangārei, providing information, education and support to understand and implement Te Tiriti o Waitangi. It was established in 1985 as Project Waitangi, so Network Waitangi Whangārei is the tainer of that original group, and we've been active in the Northland community for 40 years this year. So we are very much looking forward to the time when we are no longer needed, but unfortunately at the moment we are busier than ever. So just a quick rundown, we've got a few other events coming up which I thought you might like to know about. So next Monday, June the 9th, we've got another amazing webinar with Professor Margaret Mutu talking about constitutional transformation, which is helping us to commemorate our 40th anniversary. The 17th of June, we have the first of 4 in-person sessions at Whangārei Library exploring Mātiki Mai, which is again about constitutional transformation. And Saturday the 5th and 12th of July, we've got an online free introduction to Te Tiriti workshop with our lovely Moya Armstrong. And there's a lot more events on our website. So Claire's going to put our website link in the chat at some point in the next few minutes. And then we've got the amazing Melanie Nelson here. So Melanie, I feel like the first time I heard about the regulatory standards bill was when I saw something written by Melanie, and I feel like she was she's alerted the whole country to it, and I'm so grateful to you, Mel. So Melanie is a Pākehā. She's a researcher, writer, consultant, coach and educator on cross-cultural issues. She's also a licensed Te Reo Māori language translator and interpreter. And she specialises in the application of Te Tiriti o Waitangi and the treaty principles to conservation and environmental issues. And Melanie is a graduate of Te Panekiritanga o Te Reo Māori, Institute of Excellence in the Māori Language, and holds a Masters in Māori Language Excellence, Te Tohu Pairua o Te Reo Kairangi. So Melanie actually has a couple of podcasts, Weaving Our Worlds, which seeks to foster mutual understanding between peoples in Aotearoa, and a new podcast, Coherent, which explores current political issues. So I'm going to let Melanie take over the mic in just a minute. Just a quick couple of housekeeping things before I do that. So first of all, the session is being recorded. So all going well, we will hopefully be able to make it available to others as well. But please stay around for the whole session. I'm sure you'll get some amazing value out of it. So Mel is going to present to us for about 40 to 45 minutes, and then we'll have just under half an hour for a Q&A. So the Q&A is open, so just feel free to add questions whenever you think of them, and you can also upvote them. So we'll try to answer as many as possible after the presentation, and just try and keep the questions brief, just one topic per question. And if we normally will just allow your mic to come on so that you can ask your question yourself, but if you'd prefer us to read out your question, just put in your question that you don't want your mic to come on. But just so that you know, there's no video shown, just microphones. So you just, if you wanted to ask your own question, we can just turn your audio on for a moment. So yeah, so that's all from me. And now I'm going to ask Melanie to turn your mic on, Mel, and begin your presentation. And thank you so much, and welcome to you.
Kia ora, Jette. Thanks for the lovely welcome and introduction. Can you hear me okay?
Yep.
Yeah, cool, and lovely to be here. I'll just share my screen so people can see my presentation and my sound. All right, can you see the full presentation all right there? Cool. Kia ora koutou, o te rā tēnā koutou e whakarongo mai nei ki tēnei pānui, ki tēnei kōrero i tēnei pō, o te rā ki ngā mana whenua, kei ko koutou rohe, kei whangārei tēnā rā koutou, o te rā hurino i te motu tēnā rā tātou, koutou ngā kai whakarongo, tēnā koutou. Kia ora koutou. So I'm Melanie Nelson, and I'm originally from the South Island and do live on the South Island again now, Pākehā. Grew up in Motueka, and that's where I started learning te reo Māori at Motueka High School, and that's been a part of my journey ever since, and probably led to my interest in Te Tiriti and cross-cultural issues and building understanding between peoples because of the experiences I've had. So strangely enough, that eventually led me to the Regulatory Standards Bill, and Jette is right that it was perhaps me that started writing about it at the end of last year and bringing people's attention to it. But I do want to acknowledge that that's just one more round in a long history of people raising attention about this, right since probably about 2001. So you'll be familiar with names probably like Jane Kelsey and Jeffrey Palmer and Jeff Bertram and people like that, Jonathan Boston, who've really been trying to oppose this bill on its many iterations since it was first introduced in 2006. So once I eventually discovered their work, after I'd spent about 4 weeks delving into what this might actually do, it was good to see that I was right. Well, it was bad to see I was right because it's quite scary, but it was good to see I was right because a lot of these great thinkers before me had done a lot of work that affirmed the conclusions I'd come to. So I did come across this because I'd been working on the Treaty Principles Bill last year and trying to spread understanding of the alternative libertarian meanings in the Treaty Principles Act and David Seymour were trying to put forward. So when the bill came out in whatever month it was, eventually I was surprised there was no definitions in there, and that took me on a journey to see where the definitions might be or what other cross-pollination things might be happening, and that was how I came across the Regulatory Standards Bill, which was in the coalition agreement but sounded so boring I'd never looked it up, and at that point I thought, that's so boring sounding, I should look it up. So yeah, that led to obviously like a feeling that it was important to bring it to people's attention and awareness, and was just about to do that when the consultation then got launched, and so it became quite urgent at that point. So yeah, that was when I started writing and being interviewed and doing interviews about it in December in time for the consultation. So getting into the detail of the bill, fast forward I guess about 6 months, and we're now at the select committee phase, and many of you will be aware that submissions close on the 23rd of June at 1 p.m, not at midnight, so don't be late. We'll get into a bit of detail, and hopefully many of you or all of you will make submissions and encourage others to do the same. So thanks for making time tonight to come and learn a bit more about it. I'm going to cover its fundamentals and basics in the presentation, and then in the Q&A there'll be opportunity to ask for more specifics or work out some of the detail. Can you see that all right, or is my Zoom thing interrupting it? No, that's all good. Okay, cool. Thumbs up. So the Regulatory Standards Bill, of course, sounds incredibly boring and technical, but it's really not. I mean, it sort of is, but it's actually one of the most important bills we've ever seen. And David Seymour's recently said that it's one of the most consulted bills we've ever had, and that may be true. This is its 4th attempt to be passed by the ACT Party. They've been trying to pass it for nearly 20 years. I would say to that it's also obviously one of the most rejected bills we've ever had. So maybe the most consulted, but it's also the most rejected. Even I think the euthanasia bill passed on the first time, but this one was rejected in 2021, last time they tried. So unfortunately, it's agreed to be passed under the ACT National Coalition Agreement, not just taken to select committee like the Treaty Principles Bill. But important to know, and this is not very widely talked about at the moment, the bill's contents and the detail of it are not included in the coalition agreement. So that stuff needs to be agreed by all the coalition parties. So the agreement, I don't have it right here with me, but it's to pass the Regulatory Standards Act as soon as practicable, and it's around good lawmaking and transparency and things like that. So those things are actually quite subjective, and there's no real reason that I can see that there's any obligation on National or New Zealand First to pass ACT's version of such an act. So there's room for pressure there with New Zealand First and National around that, while they could still be adhering to the coalition agreement, which they seem often quite keen to do. So what is the RSB? Well, the word that Jane Kelsey used to describe it is meta-regulation. And so that's like really big picture regulation or legislation, which is intended to govern most legislation and regulation. So sort of like an umbrella act over the top of the rest of our acts, if that makes sense. And the initial consultation was also on it covering all regulatory systems. That's not specific currently. It's now more about legislation, both primary and secondary. But the point is, it creates this set of principles and says these principles are what good regulation is. And that most legislation and regulation should be consistent with those principles. So the real problem, or one of the real problems, there's quite a few, comes when you look at what those principles are. So some of the terms sound quite good and familiar, like rule of law and consultation and, you know, words that you're like, oh, of course, that kind of makes sense. But it's a mixture of those things and then a mixture of principles which are very ideological, libertarian ideals. So the ACT Party's ideology or values. And then even things like the rule of law and consultation, which on face value would make sense, I think, to lots of people. There's very specific definitions of those, and we'll get to that a little bit later. So they are different to what we might think we understand when we hear those words. And it looks like they're trying to limit the meanings of those in our laws. So the RSB embeds a new legal framework that would prioritise individual and property rights. It would constrain regulatory powers particularly through pressure and political leverage, and the risk of corporate legal action, and also reduce the government's ability to implement environmental protections, social safeguards, and tiriti-based initiatives, because those things are all absent from the principles of what's good legislation. So there's an attempt here to redefine what good is in the public mind. And as we'll see as we head through, there's a whole lot of layers of pressure that are orchestrated into this system, which would work to shift the culture over time to essentially refocus around the libertarian preferences. And David Seymour's been explicit that this bill is intended to shift the culture over decades. So that's an explicit aspiration, and what's perhaps not so explicit is that ideological direction the intention is to make that culture shift towards. So a little bit of history. Jane Kelsey's called this bill the final puzzle piece from the 1980s neoliberal reforms, and I'm sure some of you were there and remember those and the massive consequences and changes for New Zealand that flowed from that time. And in the 90s, the Business Roundtable, who are now rebranded as the New Zealand Initiative, were advocating for an economic constitution. And they published a report in 2001, authored by Bryce Wilkinson, who's still one of the key proponents of this bill. And it included a draft regulatory responsibility bill, which was the basis for what was introduced later in 2006, and is actually still the basis for the current bill, although, you know, a number of changes have been made over the years. So just an interesting note that the same year, 2006, that the RSB was first introduced to Parliament was also the same year that ACT first introduced its initial treaty principles bill. And we'll come back to the connection between them towards the end of the presentation tonight. So at that point, the RRB, as it was blocked by Labour. And then in 2009, it was revived through a regulatory responsibility task force. And that was ACT leader Rodney Hyde and Nationals Bill English. And then in 2011, reintroduced as the RSB. And it failed to pass. It was advised by all sorts of groups and people, like the Legislative Advisory Committee, Treasury, and others. And some of the criticism was on its focus on property rights over other values and it creating constitutional rights which were in conflict with the New Zealand Bill of Rights. And continuing that history, fast forward to 2021, David Seymour reintroduced it, but it didn't pass. And MPs condemned it as a dangerous constitutional shift, undermining public and collective rights and threatening parliamentary sovereignty. And they called the principles then political choices, which would enshrine ACT's values in place of other values like Te Tiriti, international obligations, community well-being, climate and environmental protection. So all these other things which are not in the RSB, they're actually part of the considerations for our lawmaking currently in what we call the legislation guidelines, which the LDAC committee, the Legislation Design and Advisory Committee, writes and maintains. So people can look that manual up online, the legislation guidelines, if you want to actually have a look in detail at the values which currently inform legislation. And you'll see how the ones in the RSB are a selection and a narrowing and a redefinition of a much more non-partisan set of values, which are there and I think should continue to be there. So Jane Kelsey said that if the Business Roundtable and ACT had their way back then, that these directives and guidelines would have become a legal straitjacket. So the agency consultation, which I'm sure some of you probably submitted to, if you got wind of it in time, there wasn't much time between me publishing on the RSB and summer holidays, but there was still 23,000 submissions nearly, which was amazing, and only 0.33% supported it. That's 76 out of 22,000 something. But they went ahead anyway. There were some changes made, but it didn't seem to be in response to consultation. Some of it actually got a bit worse, and the legislation passed its first reading. So it's currently at select committee stage, and some of you will have seen that there was a Waitangi Tribunal hearing by Toitu Te Tiriti claimants, and lawyer Tania Waikato was the lawyer acting for them. And the tribunal only had like 2 days to write their report because the Crown government was introducing this and taking it to first reading very, very quickly. So the tribunal recommended that it be halted and proper consultation directly with iwi and Māori be done, and that if it is enacted in the current form, it would be a profound constitutional breach of Te Tiriti. And the evidence given to the tribunal is available to read online too if you're interested in more detail. So submissions close, as I said, 1 p.m, 23rd of June, 2025. So have a look in the content now of the RSB. Up the top, there's like this overarching set of principles, and they're core to what the RSB is. And we'll come back to the principles in more detail. And then the other key components of the legislation, and you can read the legislation online if you're so inclined. One is that new and existing legislation will be reviewed for being consistent with the RSB principles. So there are a few exceptions, but most legislation should be consistent and with all of the principles going forward is the idea. And this includes regulation too. There's a regulatory standards board being created. And when I was first talking about this, I said, that looks a bit like a Waitangi tribunal for libertarians, because their role is to look at things which are inconsistent with these principles and make recommendations. We'll come back to that in more detail. And the third is that this bill creates very significant and strong powers for the Ministry for Regulation and the Minister for Regulation, which is David Seymour, both reviewing and assessing the performance of the overall regulatory system, but also to be able to gather information from all government agencies, all councils, the Reserve Bank, third-party providers, etc., for the purposes of performing that role. And that's quite a significant shift too, and the failure to provide that information would be considered a contempt of court. So with the powers that are being given to the Minister for Regulation through this, someone suggested it's almost like creating an upper house for Parliament, but there's only one law lord, where things really have to go through that before policies can be confirmed and legislation developed. And although Parliament's still free to ignore all of these requirements and to legislate anyway, there's likely to be a lot of soft power at play here and a significant chilling effect with all the layers of pressure that will come on. So let's have a bit of a detailed look at the principles, because these are really key. So there's a strong libertarian focus of some of the principles, in fact, most of them. And these principles have remained very similar across all those iterations of the bill. And we'll just have a look in detail at the first three, but they're all important. And I'd encourage you to read them, look at summaries. I've got podcasts coming out on various aspects of this too. So they're under the categories: the rule of law, liberties, taking of property, taxes, fees and levies, role of courts, good lawmaking, or maybe that one's not there now, good lawmaking and regulatory stewardship. So remember, every time we see good lawmaking, it means good according to David Seymour and ACT. So yeah, there's an attempt to redefine what good is, so that lawmaking which looks after the environment or equity or Te Tiriti is outside the norm of good lawmaking. So it's either bad lawmaking or just an exception you have to justify. So yeah, we'll get into some detail. So these slides are summaries of the principles. So have a look at the legislation for the full detail. So the liberty and autonomy kind of set of principles basically means that individuals and corporations should be free to act unless there is a clear justification to restrict them. And that includes the use of property. And it's important to notice that the bill says persons or individuals, but in New Zealand law, that includes corporations. So although some people will probably read this and be like, yay, more freedom, like we like freedom, it's not really about freedom for ordinary people. Like, it may benefit some, wealthy or landowning people in some ways, but really the key thing here is, one of the key issues is that this gives corporations the freedom to act as they want and to do what they want with their property, which is a very broad term, unless there's a clear justification to restrict them, and that justification can only be for because they're acting according to their liberties is impinging on someone else's liberty or property right. So it's not for environmental reasons or the public good or because of Te Tiriti. So very tricky with the wording there. Property rights are core here. Regulation should not take or impair property without consent or compensation. And so property, again, as well as, you know, your land and your house, it could be your mining rights if you're a big corporation, or your labelling intellectual property. There's a big broad range of things that could be property. It includes your property right to pollute, for example, a river through the work you do. So this is these principles are kind of saying that there should not be any restrictions unless it's consented to, or unless there's compensation. And the compensation is important here. As this law says that if regulation restricts property rights, and as I've mentioned before, that includes lost profits. I didn't mention that, but it does include lost profits. Say a mining license is withdrawn by government regulating to stop coal mining for climate reasons, for example, then the companies could potentially expect to take legal action or have the right to compensation for however many years of lost profits they were expecting to come under their license. So affected parties may be entitled to compensation, and there's the expectation that this will be written into future laws and regulations, and that our existing ones will be updated to include this kind of a regulatory takings clause, is what it's called. And if they don't, government will be having to publicly justify why not, and be criticised by the Regulatory Standards Board and the Minister for Regulation. So the cost to that compensation should be paid by those who benefit from the regulation. So if you think about different examples, that, for example, a zoning decision that reduces the value of land, or protection of wāhi tapu, or ecological sites on private land, that kind of compensation might fall to the ratepayer. Potentially, you could even find more specific beneficiaries at times, like iwi or hapu, who want protection for various reasons of land, or it could fall to the taxpayer if it's not very clear who the beneficiary is. There's also a real tendency in the Act, or in the bill, hopefully it won't become an act, for minimal intervention. So regulation should impose the least possible restriction necessary to achieve its objective. So this is a big push for massive deregulation, and we only have to turn our minds to massive regulatory failures that are well known, like leaky buildings or finance company collapses, rest home safety, Pike River. All of those things were clearly linked and caused by inadequate regulation or inadequate enforcement of regulations. So there's a huge amount of concern about what could happen here. Cost efficiency is another key principle, a different summary wording again. So the benefits of regulation should outweigh its costs based on quantifiable analysis. So this again can take things to a real economic calculation rather than things which are harder to measure, like the environment or preventing catastrophic climate change, social well-being, equity for those who are discriminated against or have historical injustices, etc., etc. So it's trying to take it away from those things which are less quantifiable and non-economic. It also has quite a focus on equal treatment. This is under the rule of law principle. Equality before the law, which you've probably heard David Seymour mention once or twice the last year. That laws should treat all persons identically under the law with few exceptions is really what this means. As we know, equality sounds kind of good, but it actually means identical treatment without considering what's relevant in a particular situation. And I think, you know, if you look to some recent examples like the anti-equity legislation, no special treatment for women, even though it might well be justified. The directive for colourblind healthcare, no special consideration of Māori, even though the statistics say that, you know, they're behind in every aspect with health. So all minorities and marginalised groups would be affected by this attempt to make everything standardised and the same for everybody, which, as we know, also often means assimilation and doing it the white way. So transparency and accountability are here as well in the principles, these related principles, and I've put "and pressure" in brackets because the mechanisms proposed in the bill for transparency and accountability are going to be massive pressures on the government to actually act in a more corporate friendly, libertarian friendly way. So lawmakers should justify regulation through reasoned analysis and public reporting. And while that sounds kind of reasonable, we do actually have systems for that already, just they're perhaps not always followed well, and certainly David Seymour hasn't followed them well with either the Treaty Principles Bill or this bill. So look at the actions, not just the words, around what the intention perhaps will be here. So we're missing out some important aspects of the rule of law and the rule of law stuff that's in the bill. I won't go into these in detail, but here if you want to have a skim read. State accountability and democratic legitimacy for making laws, access to justice and fair process that's designed in favour of deregulatory interests, not for those seeking stronger protections. Equity is absent, promotes individual equality but ignores substantive or collective equality. The role of law and role of Parliament and its ability to democratically make law. Collective rights or the treaty are not part of the rule of law selected components in the RSB, and proportionality and reasonableness are also not there. There's not a good framework for weighing up the economic aspects with those other things I mentioned, like the public health, safety, environment, Te Tiriti, etc. So, yeah, we've covered the rule of law, so I'll pass on to the next one. So liberties, the phrasing here, this is more detailed phrasing. So I've mentioned that it includes corporations in New Zealand law. And so this means that legislation shouldn't restrain what a person or corporation does, other than if it's to protect another person or corporation's similar right. So not to protect the environment, safeguard equity, social or collective well-being, etc. I'll just play you a little clip from Professor Jonathan Boston, who I interviewed on the RSB on my podcast, which is called Coherent. And you can check out the full interview if you're interested. I'd really recommend it.
Another consideration would be measures to protect the public welfare or enhance the public welfare. So, for example, measures to protect public health or to do things that generate public benefits, such as having a conservation estate, national parks, and so on. These sorts of things can infringe on people's rights and liberties. They can infringe on property rights and so on, but they're not justified in our kind of system on the basis of minimizing harm to another individual or their property rights. They're justified on the basis that these things are good for society as a whole. But of course, the problem with a neoliberal model of things is that kind of societies don't exist. and people are not interested from that perspective in enhancing the common good or the well-being of the society as a whole, because, well, society is irrelevant. So you know, just focusing on this principle, this liberties principle, just highlights the very, very restrictive nature of the proposed legislation. Much the same applies to the so-called takings provision that's in this proposal, and likewise the proposals in relation to taxes, fees, and levies. The way the principles are formulated under those areas would impose very significant restrictions on what governments can do. Another consideration.
Well, so he mentioned the taking of property or regulatory takings, which is another part of the principles. And this is that legislation or regulation should not take or impair or authorise the taking or impairment of property without the consent of the owner, without good justification and fair compensation. And as I mentioned, compensation provided by or on behalf of the persons who obtain the benefit from that impairment or taking. So it basically means that property owners, including corporations, if the government creates regulation or legislation that impacts on their property rights, we've run through some of those examples, and that includes intellectual property, that there's a framework by which they could expect to have compensation for that, and there'll be mechanisms to put pressure on the government to include that in those legislation. Here's Jane Kelsey talking about the regulatory takings provision.
In this bill, there is also something called a regulatory takings provision. This has never existed in New Zealand law. And what it basically is a protection of the private property rights of companies, especially if governments are to regulate in ways that impact negatively on their investment. Now, this government is going hell for leather to remove all restrictions in the way of, think of the fast track bill, of many quite harmful activities. And a future government may want to re-regulate those. That would be a regulatory takings that the companies that don't like it could take to the domestic courts and seek compensation. Now, what we don't know is there's nothing in there that gives us any detail on this, including what kind of compensation they could get, what kind of rules have to apply, whether there could be anything about, yes, but your activity is harmful and therefore there's a justification. We don't know any of that. It's a US protection of property rights rule where there is none of that, none of those protections. It's also very similar to what we have in the free trade agreements of what's known as investor-state dispute settlement, where a foreign investor can bring a case in an international tribunal against a government for adopting regulations or decisions that impact negatively on their investment. And what they claim there is not just loss of what they've invested to date, but the whole lifespan of the future profits that they were anticipating with compound interest for maybe a 30-year lifespan. That is so bad that successive governments, the Labour-led government of Ardern and the current government, have said they will not accept that investor-state dispute process anymore in future agreements. But here ACT is talking about something similar to that in the Regulatory Standards Bill, and no one seems to be taking any notice. In this.
Yeah, so Jane sums it up very succinctly, and she's been one of the lead thinkers on this sort of thing for many decades now. And you can also listen to her full interview on Coherent if you're interested. would also recommend highly. And some of you will recognise that the government recently announced regulatory takings provisions will be part of the RMA replacements as well. There's an article on my Substack actually on that and a little bit of relating to the RSB for those who are interested. Regulatory takings examples can include all sorts of things. So breaking up of monopolies or oligopolies like supermarkets, electricity, that sort of thing, or capping markups could be considered regulatory takings. Limitations on tobacco labelling have been considered and sued for being regulatory takings in other countries where plainclothes packaging is required to be less appealing to consumers because the labelling is their intellectual property or the branding is their property. Limiting pollution could be a regulatory taking because it imposes costs on the business or it takes away their property right to pollute. Protecting wāhi tapu or biodiversity on private land or in mining areas could be considered something that would reduce the value of the property and be a regulatory taking, or reduce the value of the mining license. Rezoning could be considered a regulatory taking if an area was rezoned to prevent commercial development for community reasons or ecological reasons. Taxing sugary products to improve health outcomes could be considered a regulatory taking. So all of these things, the expectation that RSB provides is that when these regulatory actions are taken, that there'd be a provision for compensation. And so I'm hearing you think, but isn't that going to be insanely expensive for the government? Which, one, yes, it could well be, and the detail of what they think that might cost isn't available in the RIS, the regulatory impact statement. It could be in the areas that have been redacted, but we don't know that. And just the cost of legal action, money and time, could be insane. So the thinking is that probably, yes, there may be a lot of costs in compensation and falling on councils and iwi and government, etc., but environmental groups even perhaps, but there is more likely and as likely to be a significant chilling effect on the policy and regulation and legislation that's actually developed because of the cost of compensation and the risk of legal action being considered in that process. Other key aspects of the RSB, it's likely to lead to extreme deregulation, as I mentioned before. It's also hostile to government discretion. So a lot of important stuff that government does is dependent on discretion. If you think about, for example, applying treaty principles or treaty recognition in policy and in applying the law, that really relies on discretion in the context of what the principles would be, how important the place or the thing is. That broader context is important. And of course, much environmental, education, like just so much stuff is dependent on discretion, and discretion's really valid and important. And this is trying to take our laws to a much more black and white, rigid set of rules that there is very little room for government discretion, but that's what administrative power means there, and that there should be review wherever there is discretion. As I mentioned before, it also gives powers to the Ministry for Regulation and Minister for Regulation across the entire regulatory system. And it also creates a Regulatory Standards Board to create to consider both new and existing regulation and legislation and assess it for consistency with the Bill's principles. So if it's inconsistent with one or more, someone can take a claim claiming that, and they need to assess it, and I'll look at those details in a minute. This is new, this last bit. since the consultation that the board would also consider new legislation. Previously, it was just reviewing existing legislation. And so that's quite a significant power, which some constitutional and legal experts are saying, you know, it really interrupts the role of cabinet and the executive there, and interferes with parliamentary sovereignty in quite significant ways. The board is a recourse mechanism, right? And it's appointed by the Minister for Regulation, and it's accountable to the Minister for Regulation. And board members, the Minister for Regulation has said, will be regulatory economists. Kind of full stop. that's all he's said. It sounds like they might all be regulatory economists. I'm not expecting to be invited to be on it. I don't think it's got a space for tiriti or environment expertise, for example. And they undertake investigations initiated either by public complaints that a law is inconsistent with one or more of the principles, at the direction of the Minister for Regulation, or the board can initiate its own reviews too. So it only has recommendatory powers and issues non-binding recommendations. And it is there are many parallels with the Waitangi Tribunal and how it's set up. And those of you familiar with the tribunal might be thinking that already. And Dr. Carwyn Jones, in his evidence to the Waitangi Tribunal, called it an anti-Waitangi tribunal board. And he called the principles anti-treaty principles. And I actually interviewed Carwyn Jones for Coherent this morning, so that'll be up in the next day or two. And he had lots of wise and insightful observations to make. So the board can consider complaints about laws, but actually I think it's changed and they can't look at the implementation now, so I need to update that. So examples might be someone takes a complaint, can't think who, someone, about laws that recognise collective Māori rights on the basis that they are inconsistent with individualistic rights and formal equality before the law. Or someone else might take, or the same person might take a complaint about environmental protections on the basis that they are inconsistent with unrestricted property rights. Or someone else might take a complaint about social safeguards on the basis they are inconsistent with equality before the law, a formal version of that, and the principles on the imposition of taxes and levies. So this was just a start, but you kind of get the gist of where this might go. Any laws that the ACT Party and big corporations don't like will likely be subject to complaint, and the board will investigate them, and they'll make recommendations that they're inconsistent with the principles of good lawmaking and good legislation, and recommend how they should be changed. And Parliament can make those changes or not, but if they don't, they need to publicly justify why not. And so there's all these layers of pressure in the public minds going on to shift over time what is conceived of as allowable in lawmaking and what is bad lawmaking and outside the norm. And so the board is likely to carry really significant political weight by compelling ministers to respond publicly and justify their actions. And so the political, procedural and financial hurdles are likely to really be quite significant from the RSB if governments want to deviate significantly from these principles. So the real risks are potential political backlash, legal challenges, compensation, administrative delays, difficult interagency coordination. So you can imagine the whole public service and agencies, as well as ministers, really slowing down or perhaps even grinding to a halt on legislating in the public interest or in support of the environment or to give effect to Te Tiriti, for example. And so lastly, I think effects on Te Tiriti or Waitangi. The Ministry for Regulation noted that there was no principle about Te Tiriti in the principles, which is very true, and a good amount of their advice was redacted and still hasn't been released. I know that there are complaints with the Ombudsman about that. Now, probably the advice was saying this is a total breach of the treaty and you should expect legal action and potentially a lot of costs, but we don't know. That's just guessing. So, as I noted before as well, this real individualistic property set of rights in the RSB seems to really butt up against and conflict with the collective rights guaranteed to hapu, rangatira, iwi, Māori under Te Tiriti or Waitangi. And treaty settlement legislation and the Mākehā Act is excluded from complying with the RSB. And that's a bit of a double-edged sword. It means that those settlements won't need to be reviewed to bring them into alignment or justify why not with the principles. But it also means that, for example, the foreshore and seabed couldn't be revisited under the RSB to say, but you're meant to give fair compensation when you take property rights, because that's kind of like about one of the best examples you can get of regulatory takings, isn't it? So this is complex here. And other treaty rights and affirmative action or equity measures are likely to be inconsistent with the RSB principles. And it was noted in the Waitangi Tribunal by one of the claimants that, I think it was from Waikato Tainui, that, you know, iwi have assumed when they've made these settlements that the all the other kind of treaty clauses and avenues for Māori rights and legislation would be continuing. And so treaty settlements aren't meant to encode everything forever. They're simply a small recognition of the historical injustice and a small percentage of compensation for that. So if you were to remove all of the other stuff which looks after the government's responsibility towards iwi and towards Māori, due to the historical injustice and for equity reasons and participation in all these things, then you'd be massively shifting the environment and leaving just the bare bones of what's encoded in treaty settlements, which is by no means everything. Much of that's in the RMA or the Conservation Act or all these other acts which are part of that ecosystem. So it's very significant implications for settlements, even though they're explicitly excluded. And it was suggested at the tribunal that it would be essentially wiping hundreds or millions of dollars off a settlement's value if iwi were then expected to pick up all that stuff themselves for looking after their people, which has always been the government's role and responsibility, and there's been no agreement for them to abscond from that. Jane Kelsey would go so far as to say that essentially this act would achieve everything the Treaty Principles Bill set out to do. So it would remove Te Tiriti from the list of considerations that inform legislation aside from treaty settlement. So I said I'd come back to this connection with the Treaty Principles Bill, and aside from that they were both introduced for the first time in 2006, albeit a different formulation of principles in the TPB then, they do have the potential to intersect in quite interesting ways. They're both actually very similar sets of libertarian principles in both. Many people are unaware that the principles that were proposed for the Treaty Principles Bill have very specific libertarian interpretations, which mean quite different things to our common usage. There's also an article on my Substack about that. I think that was in December. So the rule of law, human rights without discrimination, equality before the law, free and democratic society, these things that are in the TPB, they actually all revolve for libertarians, their definitions around individualism, property rights, and minimal government intervention. So there's a lot of similarities, The RSB shapes how legislation and regulation are developed and implemented and determines the foundational values that these are based on, whereas the Treaty Principles Bill was concerned primarily with how legislation is interpreted. So you can see them coming together as a perfect capture or ideological takeover of both the creation and interpretation of legislation, and either on its own would do much of the damage that the other would do with it. So the RSB principles will displace or deprioritise Te Tiriti to be outside of our good normal process of lawmaking, and they're currently very strongly in there in the legislation guidelines. It'll put these anti-treaty principles in there instead. If only the RSB is enacted, but not the Treaty Principles Bill, and they have said they'll be back with it, so who knows. Under common law, we might still have to consider the treaty principles, the real ones, in legislative interpretation unless it's explicitly excluded. And that would create real constitutional tensions. So the RSB has this individualistic, property-focused framework, and it really conflicts with the tiriti and common law principles of Te Tiriti, which is around collective rights and interests of iwi and hapu. And possibly it was that conflict that prompted efforts to redefine the treaty principles in legislation right back in 2006 as well, to make them run parallel to the libertarian rights outlined in the Regulatory Standards Bill, which was introduced that year as well for the first time. So last slide, what can we do? We can do lots. So it's obviously really, really, really important. And the RSB would really totally reshape New Zealand's economic, social, environmental, and political landscapes as the legislation and regulation is reviewed under it over time. So we can develop our understanding, which you can all tick tonight. Think about how it affects the areas you care about. And we've actually just released a new Regulatory Standards Bill 2 today, which has got a humongous number of questions that are specific to different sectors. So you can go into the tool and there's a bunch of questions that you can consider whatever your sector or area of interest, and then there's a contents. And if you find the category and then the subcategory of what you're most interested in, whether that's health or the regulation of AI and the internet, or having a blank workers' rights, whatever it is, the environment, and there's about 8 or 10 sections, I think, on different treaty and Māori aspects. Go in there and there's like about 15 questions in each category that are reflective questions to think about how the principles might reshape the sector that you work in or are interested in or care about. So really good conversation starters, things you might want to consider writing about in your submission if you want to put some time and thought into your submission. They're all questions the Select Committee should answer, but you know, the public are going to need to give them the answers, or at least deepen those questions. And really there could have been thousands of more questions in there as well. So also just having a skim of the document gives you the flavour of how it really is the everything bill. So share information with others, network, lobby MPs, and make a submission. Kia ora, that's me, presentation done, Jette, and here's some resources. And yeah, I'll hand back to you for questions.
Kia ora. Thank you, Melanie. That was awesome. And just before we go to questions, I'm just going to post a few more links up to Melanie's website and her lovely Weaving Our Worlds podcast, which I can imagine you would prefer to be going back to rather than dealing with this. So I'm going to start with, because we've got one question that's been upvoted with, so I'll start with that first. That's for Brett. So I'm just going to Look, just for the sake of time, I might just read them out and not put everyone on mic because there are a lot of questions. So Brett wants to know, if the bill is passed, is there any reason that it cannot be subsequently repealed or thrown out?
Yeah, good question, important. So no, it should be able to be. It shouldn't be entrenched without a supermajority, given it's not going to public binding referendum, although the 2021 bill was proposed to, this one's not. So hopefully it can be repealed. We would expect probably massive pressure to be coming on all political parties to not repeal it from the, big moneyed interests that will be wanting it to be in there. There's also, it could do a huge amount of damage next year. It's going to come into force on the 1st of January. And then especially if the coalition gets in again, there's a lot of damage that could happen then. Labour has said that they would repeal it in their first 100 days. And so I think the pressure really needs to be on through the select committee process so that that's a viable thing for them to do, or maybe even for the opposition parties to campaign on. I don't know, but yeah.
Sorry, can I just ask another quick question around that? If it is repealed, is the government in New Zealand then liable to be sued by all the companies who've gone ahead on the assumption that it's in place?
Yeah, I would like to know the answer to that question too. It doesn't in itself create an avenue for legal action. There are some concerns about the hooks of it into international agreements that could perhaps create those avenues, judicial review, and then the various, property rights that may have been created under fast track or something that they might want to draw back. So it's a bit more complex legal stuff than I quite know the answer to. But yeah, really important stuff to explore if you can find some information on that to include in your submission.
I'm not doing these in order, so just so that some of the probably more specifically relevant to your talk ones can be answered first. So Fiona wants to know, I did a submission earlier in the year, read this bill. Can I do another one now?
Yes, it's important you do, because that one won't count in this process. So that was one which went to the Ministry for Regulation, and it seems they largely ignored. But this is a select committee process, so you can take your old submission and just tweak it a bit to put it into this process. And so it's important that everyone who submitted in the last round does submit again.
Okay. Here is someone wants to know, would you share your slides later? So I mean, we are recording this session and we plan to make the recording available, but Melanie, would you also be willing to share your slides?
Yeah, let's do it that way through the recording. That'll be best.
Okay, thank you. And then we've got one, does the fact that this bill will be heard by the Finance Committee and Expenditure Committee prejudice how it will be heard? Like, i.e., do terms of reference vary from committee to committee?
I don't know the answer to that, but it's an interesting question. But there are, there's a wide range of MPs on that committee. So people like Chloe Swarbrick's on it, Rawari, and from Te Pāti Māori. Yeah, but I'm not too sure. I think each select committee for each bill sets up a process, but if there are differences, I'd be quite interested to know.
So, kia ora, Melanie, how does this bill impact nursing and medical councils?
Yeah, good question. Quite significantly, I think. So I'm not an expert in that area, but I am interviewing Dr. Gary Payinda, and that'll be out this week. So we'll be talking through that stuff. I think it's really significant. If you think about the way healthcare works at the moment, there's a focus on it, being economically efficient, but it's also a lot around, achieving good outcomes for patients and equity and all those sorts of things. If you look at perhaps, say, the takings or the property rights kind of principles, then what kind of implications does that have for regulation which favours public health? If you look at the taxes and fees and restrictions on redistribution, which this bill also attempts to do, there's significant implications for the funding of a public health service, and I think efficiency and those kinds of economic balancing acts, leaving out the public good, for example, or Te Tiriti. There's a big likely to be a big momentum towards privatisation of health with this. And then when you look at the specifically like the regulatory systems governing professions, then you know, I think probably the consultation we're seeing at the moment on how those professions are regulated is perhaps just a drop in the bucket of the sorts of shifts that could happen if the RSB was applied full scale by a really committed government to it across the board. So taking at the moment the proposals are sort of moving things away from it being the professionals who know stuff regulating themselves to it being quite a different setup, and the government having more control and with a different sort of set of perhaps reference criteria. So I'd encourage the person who asked that to go and look at our tool, because there's some in there about public health and workers' rights. We might add one about nursing. That's a good question, and I know that the nursing boards and unions are paying attention to this bill, so it could be a good source of information, or might appreciate some interaction with you on that.
Oh, so here's one. I'm not quite sure of the name of this person because it doesn't. It looks like a pseudonym. There are no definitions in the bill of the terms used in the principles. It is obvious what Seymour thinks he wants, but is there room to insist on definitions that include non-white cultural understandings of property owner liberties, etc., etc.?
Yeah, really good question. I love these questions tonight. Yeah, well, that's what I thought when I saw the treaty principles bill. I was like, there's no definitions, but I'm listening to his narrative. I know what he thinks they mean. He's not dumb, like there'll be a way. So that's how I found the RSB going, oh, if you applied these interpretations to that TPB. So the answer is similar here. Listen to the narrative, see what's being said. I'm pretty sure the ACT Party are not putting something through that could promote substantive equality and equity or collective property rights. So one is, if you really look at the detail within the principles, it's all very individualistic. And so there's significant questions and doubts as to whether that would apply to collective ownership, for example, around property. And there's some good questions around even intellectual property and mātauranga Māori in the tool I mentioned. And the other thing is that the Minister for Regulation will issue advice and guidance on how the principles will be interpreted and applied. And so there's the answer, is that it's sort of hidden a little bit separately, that's down to David Seymour, essentially. And with it coming in the 1st of January, there's a big rush to get it through, no doubt, so that if they're out of government, at least he's done all the advice and the interpretation, I suspect. So yeah, probably fairly low risk that the thing you're hoping will happen. But I think, you know, showing those differentials about the meanings and keeping people aware of that is really important.
Here's an interesting one from David in Whanganui. I just got thinking today that this bill could well impact upon te awa tupua, or the personhood of the Whanganui awa. What are your thoughts about what could happen with the recognition of te awa tupua's personhood with accompanying legal rights and responsibilities enshrined in the Te Awa Tupua Act 2017?
Kia ora.
And someone else texted or put in the chat a question, the same, I think similar. Would legal personhood of Maunga River, etc., make it possible for that awa to claim?
Yeah, it's a really interesting one. I heard this question asked to Tania Waikato the other day, and I agreed with what she said in response, which was that, and I think the person asking was mentioning that Te Awatupua had been, someone had tried to sue Te Awatupua for flooding damage last year or something. And yeah, her response was like, yeah, that's a risk when you create personhood, which can sue, but is also suable. So while it's, acknowledging the mana and the fact that awa or maunga or roto or whatever is an entity, bringing it into the Pākehā legal system in that way has other flow-on effects as well, which some of them are great and some of them could be very difficult. So yeah, I think that will be very interesting. And I'm not sure, I don't think it would affect the legislation for Te Awatupua or Te Uruwera, for example, because they're parts of settlements, as I understand it. So it's not just settlement legislation, but things which are treaty settlements. So I don't think that legislation would have to change, but it does seem like, on a face value reading of it, to create both rights and liabilities that would apply to Te Awatupua as a legal person. So yeah, it seems like it might entirely be possible that it could sue for regulatory takings if it was so inclined. But I think the thing is, because people often say, but couldn't we also take complaints to the Regulatory Standards Board, those of us who don't like this stuff? And I'm like, yes, we could, but why would we? Because the only possible complaint is that a law or regulation is inconsistent with these principles we don't like. So we would then probably like that law or regulation and not want to take a complaint about it. So you can't take a complaint that it's causing pollution or not upholding Te Tiriti or something. So it's that kind of complicated situation where, sure, you might have those rights, but would they be something you'd actually want to complain about? So yeah, very good question, and I'm going to be so interested to see how that plays out if this passes.
So we had 2 more questions. We've just had one more pop up, so I'll just suggest people don't ask any more questions now, and we'll just deal with these last 3. So this one: will hapu and iwi be able to get compensation for their losses if it becomes retrospective?
So one of the principles is that laws shouldn't be retrospective, but in saying that, it kind of takes some retrospective action because it reviews existing legislation and will rewrite it, but it won't rewrite its meaning. So the meaning of, a 1990 law that it rewrites now, that would be the new meaning going forward, but it wouldn't apply that meaning back to 1990. So in that way, it's not retrospective, but it will change what the intent was of those acts that were passed in the past, if they're rewritten under the RSB. But no, because treaty settlements are full and final, and also the treaty settlements are excluded from being brought into consistency. So as I mentioned before, they won't be reviewed under the RSB, and that's the double-edged sword, because the good things which are in there which are inconsistent with the RSB will remain, though it may get much harder to implement them. For example, special participation or participation in decision making or something. And the other edge of that is that iwi and hapu are probably stuck with the 1 or 2% of the value that was lost. Whereas, David Seymour has said a few times about this bill, well, if this bill had been in place in 1840, would have been much better for Māori. And what he means by that is, if it had been in place, then there should have been fair compensation for what was taken through legislation and regulation. And yeah, it's an interesting argument for him to make. But There may be some situations, for example, I don't know perhaps what this would mean for the tents case. That would be a really interesting one to explore in terms of things like perpetual leases. It could actually make them even harder to end because, I mean, they're hard enough anyway, but you think of the property, the land as being the property right, but actually a lease is a property right. And so that's actually the stronger property right over the land ownership. And so if the government was to cancel perpetual leases or shift them back to iwi or the, you know, land traditional owners, they could be lumped with the expectation of significant compensation beyond what you might imagine today for those leaseholders, you know, potentially looking forward for the whole duration of that lease, what their profits would have been or something. Like, I mean, who knows how this will all play out. But yeah, I think there are quite interesting questions to explore for iwi and hapu about, you know, if this does pass, what might some of the benefits be? But I think overall it would be probably significantly detrimental to iwi and hapu.
Thanks, Mel. That was an amazing response here. And so this is another slightly complicated one. Does the words "except as it is necessary under liberties" mean legislation should not unduly diminish a person's liberty, personal security, freedom of choice or action, or rights to own, use, and dispose of property, could unduly diminish a person's liberty, personal security, freedom of choice or action, or rights to own, use, and dispose of property if their property rights are threatened? Does that make sense to you?
I'll just jump in and see if I can see that because I didn't quite take it all in.
And maybe I can just turn David on to ask that question again because I feel like it's David, I'm just going to turn your mic on for a moment. If you could just unmute yourself. Oh, it looks like he's, oh yeah. Are you there, David? No, it looks like we can't hear you.
I think if David joins, he can start talking over me, but I'll just give the answer of what I think is being asked. So the except as necessary in that liberties one. So legislation shouldn't diminish a person's liberty, personal security, freedom, or choice of action, or choice or action, or rights to own, use, or dispose of property. So all of those things, legislation shouldn't do any of that, except as is necessary to provide for or protect any such liberty, freedom, or right of another person. So what that means is that, say, I build a 10-story skyscraper on my property, but in doing so, it means that my neighbour can't build one. Like, there perhaps should be some regulation around that, because although I have the freedom to do what I want with my property, that might limit what they can do with their property. But if someone says, oh, you shouldn't build a huge development on your section there because the runoff into the river will be awful and that's our drinking water, well, that's not another person's property right or individual freedom. That's the public good or the environment. So that wouldn't be seen as a justifiable reason to limit my ability to build this big property development. It can only be, or should only be, limited based on someone interfering with someone else's property right or freedom or liberty. So it links back to you can only limit someone's freedom to do something. It's default that you can do whatever you like, basically, with everything and your property. And the public good or Te Tiriti or the environment are not reasons to limit that. which of course they currently are, you can only do it because of another person or corporation's individual similar kind of right. Does that make sense?
That makes sense to me, Melanie. So we've got a really good question, I think, to end with. How can we slow down the process of this bill? Should we be proposing amendments to the bill or just stating our opposition?
Yeah, so I think it's important to first and foremost state opposition, if that's what you feel. And so state the opposition, but yeah, if there's amendments to suggest, do that. I know it was the claimants to the Waitangi Tribunal said they're not seeking just to have a treaty principle included, because it would still be an awful piece of legislation and extremely detrimental to iwi and tapu and Māori generally and the nation more broadly. But I think there are some good amendments that could be proposed, and there's some work being done on those. So yeah, if people want to follow my Substack is probably the best place to know you'll get a notification when we put some stuff out about that. That's Melanie Nelson on Substack. I did ask Cowan Jones that today too, and I can't remember exactly what he said, but he had some good suggestions, so they'll be in the interview, which will go up on Coherent probably tomorrow. Yeah, so I think it's a good idea to be suggesting amendments as well, because, and especially like, you know, you could be a National or a New Zealand First voter and not like the RSB, and you know, I'm sure there's a significant proportion of their voter base that actually wouldn't like some quite big parts of it. You know, New Zealand First was founded on stopping corporate takeover of New Zealand and anti-neoliberalism, and here they are seeming to be ushering this one through, but they may not have really quite got their heads around what it would do in the coalition agreement. But, you know, they're signalling that they'd like to see some changes to it, and actually Christopher Luxon signalled that too. So, you know, you might think of amendments or arguments to make to those MPs directly and in your submissions, I'd do both if you can, about why they wouldn't be supporting it. And remember, they're not that into the treaty or the environment or anything, but, you know, what are some of these other reasons, like around certainty or small business growth, all those, you know, the price of electricity and those sorts of things. So yeah, if we can have amendments going in as well that they might be quite amenable to putting in, which may also slow it down, because Cabinet has to agree after the first reading what changes will be made, and we have both New Zealand First and National signalling they'd like changes. So if their changes make it into a bill that ACT actually doesn't like, given how long they've tried to progress this very ACT-centred ideology through this particular type of bill, there could be some really interesting conversations in Cabinet. So let's give them reasons to have some interesting conversations, and yeah, if it does slow down and doesn't get through this year or this term, that would be an amazing achievement.
And just one more thing, I just picked up on you saying there, when you talked about submitting, Melanie, to email MPs, do you think it's a good idea to email individual MPs as well as putting in your submission?
Yeah, I do. And
local MP, especially the National and New Zealand First ones?
Yeah, and go and have a talk to them as well. Like, you know, a lot of them probably don't have much of a clue what this bill is or might do. And to be interesting to talk to them about, hey, what do you think the implications might be in this area? I'm concerned about this. And, you know, the questions we've got in our tool would be, some of them would probably be quite useful to discuss depending on what your MP's interests are. So yeah, I'd really encourage those conversations, and, you know, talking to your whānau and friends that are supporters of the current government parties as well. And yeah, you don't have to be against everything they do to want to stop the RSB or slow it down as well. So yeah, I think not making things not too black and white about being you know, just against this government, but actually it's this bill and there are serious and legitimate issues with it. So yeah, letters to the editor, those sorts of things, have an effect on building public awareness, because there's a huge lack of awareness, letting organisations know that it affects them and their interests. And you might find some stuff in the tool you could send to the local union or a local disabled support group or whatever it is. So activating people to be aware and take some action. Thank you, Mel. That was absolutely amazing. Thank you so much for your time and expertise on this matter. All of the links to Melanie's Substack, podcasts, website, and regulatory standards bill have been put into the chat. So we will make this video available for other people to watch soon after we close in the next few days. And also just there will be, remember that the Network Waitangi Whangārei.org.nz website has a lot of information and resources available through it as well, and links to further events. So I'll just close us with a karakia, and thank you all very much for joining us. I'm glad that we had so many people come on, and I hope that this has inspired you to not only do your own submission, but talk to family, friends, colleagues. As Melanie said, it's not just about a left versus right issue. It's a fairly serious proposal that could affect the whole of New Zealand law for decades to come if it's allowed to pass. So I hope you take this information and spread the word. So I'll just close us with a karakia now. Unihia, unihia, unihia te uru tapu nui. Kia wātea, kia māma te ngākau. Te tinana, te wairua, i te ara takatu. Koia rā e rongo. Whakaira ake ki runga. Kia wātea, ai rā kua wātea. Okay. Pō Māori. Pō Māori, kia ora koutou.